Ryan from Carson Law to come in and speak about spas, some of the issues, when everyone should be involved. So just a little preamble, we've had files in the past where we've determined that this should be an asset sale, and there's reasons for it, and those reasons the lawyer might not have been aware of, and when he finally does get to the lawyer, they're saying, why isn't this a share purchase agreement? And I guess our concern is there's a reason we did that, and the lawyer gets involved and it almost could kill that deal by bringing in that suggestion. And I think the way we try to deal with this is get lawyers involved as soon as possible. What do you see on that kind of issue where you're bringing up something that maybe you weren't aware of because it had already been discussed earlier on?
Yeah, so I think earlier involved the better, even if it's just at a high level to start, like understanding the client's motivations to sell, where in an ideal world they see themselves after the sale occurring, understanding and appreciating the motivations and everything that's gone into or is going into the negotiations, both from their personal point of view, but then also from your perspective as their advisor. I think that really helps us as lawyers appreciate where people want to go, right? As opposed to just kind of coming in last minute, or if we don't even, have that kind of dialogue with you guys as the advisors and the clients, and we just kind of come in and say, well, this is not a perfect agreement, and it's not because of A, B, C, and D, right? Most deals are never going to be perfect because, they're adversarial by nature, like they're parties against one another, right? So, if you get a perfect deal for one party, it means it's probably not great at all for the other, and vice versa. It's got to have both parties kind of getting a bit of both of what they want and maybe giving something up, that they'd love to have, but they can't, right? Because of the way the deal needs to get put together, right? So I think that's always like the biggest hurdle for us is just kind of making sure in the, whether it's a share purchase or an asset purchase agreement, making sure we understand the client's motivation, understand what they're hoping to get out of the deal, making sure that's in the paperwork, from their laypersons to the legalities, making sure we're covering off risk for them, safeguarding them, and making sure the reps and warranties of the deal, the conditions and terms, to your point, aren't going to kill what's been talked about at the negotiation and LOI stage. We want to protect our clients. We want to make sure the deal goes through though as well. And so the sooner we're together with the clients and you and the accountant, the better we can work holistically to make sure it goes through. That example you gave where you guys put a lot of time and effort to make it a asset versus a share. Obviously, a share is great for a seller for tax reasons, but there were very good reasons why you didn't do that route. And I think we just need to appreciate and understand that from you at the beginning of the process, so we don't come in behind and say the exact opposite of what you and the accountant have been saying. Right? It looks bad if I think we're trying to say, oh no, I can't do the deal because it's not sure. So we want to be supportive of the advice that you've given, and just be a further advisor to make the client realize, yeah, sure, share would be great, but like Ryan Portage and your accountant have said, there's the reasons we can't do it, and so we have to move in a different direction.
Yeah, exactly. I think the whole deal team get involved early so you can push this deal to the finish line. Like you really do, you need to push that deal to the finish line. So even if, say you are brought on earlier, the deal team is brought on, what do you find some of the biggest challenges when you do actually get to this spot?
I think the biggest challenge is really just getting the reps and warranties and the terms, like in the legalities in the black and white, to match with like what's been discussed, right? Especially with some clients, they're very, it's old school. It's like, I can give you a handshake. I want to feel like we can just talk about this and we can just, you give me money, I give you a business type of thing, right? And so it's taking that really, really unsafe approach, right, from a legality standpoint, and putting it into like the safer confines of a legal binding agreement, but doing it in such a way that it's not overly legalese, People can understand it. Like, you don't need your lawyer to read it to you, to tell you what it says. We want people to be able to read it and understand, hey, this is what it says. But also make sure, people are good at kind of doing point A, but they're not good at like sub A, sub B, sub C. It's kind of the layers to situations that we start to unfold for people and make them realize, oh, I didn't realize working, another year also means, these things. And so it's just making sure that's all there, I think, is the most important part, and sometimes the most challenging.
Yeah, that's what we find. It's these weird issues you might have not went into super great detail. The employment agreement. One of the companies owns the building that's everyone's operating. What's that rent, or what are the terms of that rent? Things that might not have been discussed in great detail until the SPA actually is in place or written by the lawyer.
Yeah. Well, it was great to chat to you today about purchase agreements.
Great. Thank you.